with the legal, it's two-pronged. Mumia was appealing to get a new guilt phase trial or to get a preliminary hearing that could have led to the new guilt phase trial. And of course, the district attorney is appealing to execute Mumia without the benefit of a new sentencing hearing. So I'll start with Mumia's appeal, which was rejected in April of this year. The United States Supreme Court refused to consider his appeal. And what he was doing was he was appealing the decision from the Third Circuit Court, which came out the year before. And the Third Circuit Court was considering 3 different issues which could have led to a new trial. They rejected all of these issues. But on the one issue, the one of what's called Batson, based on the 1986 case Batson versus Kentucky, there was a dissenting judge. It was a 3-judge panel, and it was 2-1 ruling against him. The dissenting judge wrote a scathing dissent. Okay, I'll quickly explain what Batson is. In a nutshell, it says that a prosecutor cannot strike a juror because of their race. In this case, we're talking about black jurors. And in Mumia's case, the prosecutor used 15 peremptory strikes. He gets 20 if he wants them, but he only used 15. He used 10 or 11 of those strikes against black jurors. And these are strikes where you can remove a juror without giving any reason for it. Now this evidence, using 10 to 11 out of 15 of your strikes against black jurors, is Judge Thomas Ambrose, who wrote the dissenting opinion. He said that that is evidence enough to give Mumia this preliminary Batson hearing. And the judge specifically stated, and he gave numerous examples why, on how in rejecting Mumia's appeal on this, the justification that the judges gave was wrong. They created new rules which went against their previous precedents. They created these new rules to deny Mumia. Now, we've been saying this for years, us folks in the movement, so we know this, but to have a federal judge saying it and to spend 40 or 50 pages documenting it, it's like this opinion here that the court put out. It documents it very well. This is an outrage. We need to be talking about Judge Ambrose and how he wrote his dissent. But unfortunately, this appeal's over because the Supreme Court wouldn't hear it. Now, outrageously, at the same time the Supreme Court denied Mumia, they decided they were not going to rule on the DA's appeal. Now, to explain the DA's appeal, I want to start going back to 2001. 2001, you had District Court Federal Judge William Yon. He ruled that, based on this Mills precedent, Mills versus Maryland, I believe it's also from the 1980s.
88.
88, okay. And what it said was that in Mumia's case, there were jury instructions given orally by the judge and the actual instruction forms given to the jurors. Excuse me, I got this cold for about 2 weeks now. These instructions were unclear. And because of the unclear instructions, the jurors could have believed that they had to agree unanimously on mitigating circumstances instead of individually. You know, it didn't have to be unanimous. Okay. So, in 2001, Judge Yon overturned Mumia's death sentence. Overturned should be in quotes, of course, because Mumia never left his cell for a minute. He's never gotten any of the privileges, quote-unquote privileges, that you should get if you move to general population, such as contact visits with family, which I'm sure Mumia would have appreciated since he's never been able to touch his grandchildren, hasn't touched his family since 1982, you know, which is part of the torture they put people through. So they held him there because the district attorney appealed it in a particularly sadistic way. The courts did not have to grant the district attorney's appeal, making him stay in his death row cell while the district attorney appealed. They didn't have to, but they chose to grant it. Okay, so Mumia's never left his cell. That's just the point I wanted to make. But what the court ruled is that if the district attorney wants to reinstate the death penalty, they have to hold a new sentencing hearing. You can also call it a sentencing phase trial, because a whole new jury gets impaneled to decide on this. Now, evidence of Mumia's innocence, new evidence that has come out since his original trial, this stuff can be presented. Evidence of innocence can be presented. But, of course, the jury cannot decide on guilt or innocence. The jury can only decide between life in prison with 0 chance of parole or reinstating the execution. Okay. So what the district attorney is doing is they're appealing that order altogether. Okay? So what they want to do is have that order overturned so they can just execute him without having the sentencing hearing. So they had appealed that to the Third Circuit Court, and the Third Circuit Court was unanimous, 3-0, in ruling that they were overturning it in favor of Mumia. So they are appealing to the Supreme Court. And the Supreme Court says, okay, we're not going to make a decision on this yet. Now, apparently, there's a reason for this. And Jeff Mackler just wrote a good article on this, which is back on the table, talking about this. There's a case from Ohio called Spizak by an abhorrent individual, a white supremacist who murdered people, who boasted about it, who wore a Hitler mustache to the courtroom. Okay? This guy has, the Mills issue is involved in his case too. This Mills issue I was talking about with instructions to the jury. Okay? So the court is waiting to figure out this case because this could change a precedent that could then affect Mumias and could then be grounds for reinstituting the death penalty against Mumia. Okay? Now, the Spizak case, they had oral arguments on October 13th. So there could be a decision from this really any time. Courts are unpredictable. It could be 1 or 2 months. It might be a year. Who knows exactly? But there's a real good chance, and this comes from the Legal Intelligencer. This is who wrote these series of articles. It's a prestigious mainstream law journal out of Philadelphia. The article calls Mumia a cop killer. If you read the articles, you're going to have to stomach some other language. But they have a very important point here about how really close to being executed Mumia really is. Okay? And, of course, this is important, as I don't really have to say why that's important. Okay, and this is what we're waiting on right now.